Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. So, it is our regular practice that we recite preamble before proceeding with the topic. So, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. I welcome each one of you to our 66th lecture series. In this lecture, we will be discussing about a leading case provided in serial number 81 of AOR revised cases. The name of the case is Government of NCT of Delhi and BSK Realtors Limited. It is reported in 2024 volume 7 Supreme Court cases 370. Dear friends, in the previous lecture, that is 65th lecture, we have discussed about the summary of the judgment. What is the complete facts, issues, how the issues were discussed, and what is the ultimate conclusion arrived by the Honorable Supreme Court. So let us keep that summary of the judgment, what I have discussed now, that will be a guiding light for us. By taking guidance from that lecture, let us approach what is the facts, what is the issues, and how those issues are discussed by the Honorable Supreme Court. Now let me take you to the introduction, dear friends. Judgment. They have provided, the Honorable Supreme Court has provided a complete table of contents, how they have discussed in its entirety about the judgment. Firstly, preface. Second aspect is brief resume of facts. C, judicial trajectory. D, categorization of cases. E, submissions made by the respective parties. Then F, analysis. G, conclusion. So for our exam point of view, I will take you to the preface, summary of facts, then analysis, then conclusion. This is what we are going to focus. Before going to the facts of the case, the Honorable Supreme Court at the outset, they have dealt with preface, introductory, what is to be kept in our mind. First maxim is, let me read, dear friends. We are confronted, the Honorable Supreme Court is confronted with a peculiar situation where the Latin maxim, you must remember this, even if you forget the maxim, you should not forget it to explain it in English. Interest republicae would sit finis litium. I repeat, interest republicae would sit finis litium, which means it is in the interest of the state that there should be an end to the litigation. This is one of the principles of res judicata, dear friends. Res judicata is based on one of these principles, that it is in the interest of the state that there should be an end to the litigation. Notwithstanding, it is the state itself, here the state government NCT of Delhi itself initiated a second round of litigation before this court after culmination of the first round and sown the seeds for days of hearing, engaging our attention to erudite arguments from the learned counsel on both sides, we are now tasked to decide on which side the court should lean. So they have highlighted about this maxim. It is in the interest of the state that there should be an end to the litigation, but still the second round of litigation is initiated by the state itself. That is number one. Number two, the quest for primacy between private interest and public interest. So private interest is private interest of BSK Realtors versus public interest is DDA acquiring the land for public purpose. So which will prevail? Whether private interest will prevail or public interest will prevail. The quest for primacy between private interest and public interest has been a matter of debate for years together. The scales, however, seems to have tilted ever so slightly in favor of the public interest, because it is a settled principle of law. Public interest will always prevail over the private interest. Yet, between the devil and the deep sea, we endeavor to construct a bridge. That is, they are referring to private interest is there, public interest is there. We are trying to harmonize both by building a bridge. Yet, between the devil and the deep sea, we endeavor to construct a bridge, a setu, to strike a harmonious balance for the greater good, all while adhering to the enduring Latin dictum, Salus Populi Suprema Lex Esto, a principle that reinforces the paramountcy of the people's welfare as the supreme law. People's welfare as the supreme law. So that is the second Latin maxim, dear friends. Meaning thereby public interest will prevail over the private interest. The para 5 of the judgment, there is one other aspect which needs emphasis. Justice alone of all virtues implies a notion of duty. As judges of this court, we are duty bound to not only uphold the law. Generally, we say judges are meant to uphold the law. Not only that, we are duty bound to not only uphold the law, but also ensure its consistent application. In navigating through the crisis, chaos, and confusion presented by the several sets of appeals before us, we are committed to ensure consistency, clarity, and coherence, and strike a delicate yet necessary balance to arrive at a harmonious resolution. In the course of rectifying the aftermath of rulings and overrulings and grappling with complexities surrounding questions of limitations, maintainability, merger doctrine, etc., our commitment to justice remains resolute, very strong, very firm. So they have highlighted three aspects, dear friends. Firstly, it is in the interest of the state, there should be an end to the litigation. So from this, they are questioning the second round of litigation initiated by the state itself. Number two, striking a balance between a private interest and a public interest. Public interest will always prevail over the private interest. Number two. Number three, with respect to the duty of the judges, not only to uphold the law, but also to maintain clarity, coherence. That settled principle of law should not be unsettled, because unless and until the law is settled, the Honorable High Court and other courts will follow those settled principle of law by the Honorable Supreme Court. So it is a duty of the Honorable Supreme Court not to unsettle the settled proposition of law. For example, dear friends, in Keshavananda Bharati case, everybody is aware that basic structure doctrine is propounded. And thereafter, it should not be changed that there is no basic structure doctrine. We should not change that, because it is well established doctrine to maintain certainty, it should not be disturbed. Now 14, 19 and 21, golden triangle, it is not disturbed. Basic structure doctrine, it will be there forever because it protects welfare of the people. It gives it the power vested with the basic structure doctrine is the Honorable Supreme Court's power cannot be taken away by the Parliament. If it is being taken away directly or indirectly, the basic structure doctrine will apply and say, and the Honorable Supreme Court will say it disturbs the basic structure. Therefore, it is null and void. So, these are the three principles, dear friends. Before dealing with the facts itself, the Honorable Judges has dealt about these principles. Now, brief facts. The facts are noticed from the civil appeal. They are talking about first round of litigation, dear friends. The facts are noticed from the civil appeal arising out of the writ petition initiated before the High Court of Delhi by the first respondent, that is BSK Realtors LLP. They have preferred a writ petition before the High Court of Delhi. Land acquisition proceedings has been initiated under the Land Acquisition Act 1894 to acquire several parcels of lands. This lands belonging to BSK Realtors also, comprising of the some measurement survey number is given, dear friends. Thereafter, the High Court, via its judgment and order dated 11th of January 2016, allowed the writ petition, meaning thereby it has allowed in favor of realtors. In so allowing, it relied on the decision of this court in Pune Municipal Corporation versus Harakchand Misrimal Solanki. This got reported in, please note down, 2014. This Pune Municipal Corporation was reported in the year 2014, volume 3, Supreme Court cases, page 183. So, the Honorable High Court relied upon the Supreme Court judgment Pune Municipal Corporation and similar line of decisions. So, what was held in Pune Municipal Corporation? Let us see. It was held in Pune Municipal Corporation that if any one of the two ingredients of section 24 subsection 2 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 was attracted, any one of the conditions. Either, what are those conditions? Either the physical possession of the land was not taken or the compensation was not paid. As the case may be, the acquisition proceedings under challenge would be deemed to have lapsed. So, if any one of the conditions are fulfilled, that means acquisition proceedings deemed to be lapsed. As a matter of fact, the High Court found all the ingredients of section 24 subsection 2 of 2013 Act as interpreted by the Supreme Court to be satisfied despite award dated, and hence declared the acquisition proceedings to have lapsed. Now, DDA is aggrieved. Aggrieved thereby, the beneficiary of the acquisition proceedings, Delhi Development Authority, carried such judgment on order in appeal, praying for it to be set aside before the Honorable Supreme Court. So, after granting leave, a bench of two honorable judges of this court, two judges, via judgment and order dated 31st August 2016, dismissed the civil appeals. It was observed. So, why it was dismissed? It was observed that the issue in principle had already been adjudicated against DDA in a previous judgment and order of a coordinate bench of this court in a related matter. DDA was granted, this is important, dear friends, because Article 142 is invoked because of this liberty. DDA was granted extension by a period of 1 year to avail the liberty of initiating acquisition proceedings afresh under section 24 subsection 2 of the 2013 Act. This marked the culmination of the first round of litigation. This is what the first round of litigation is. Now, let us move on to the second round of litigation. However, on 6th of March 2020, a decision in Pune Municipal Corporation was overturned by a constitution bench of 5 honorable judges in Indoor Development Authority versus Manohar Lal. Please make a note of it, dear friends. Indoor Development Authority versus Manohar Lal. Let me tell you the citation also. 2020, Volume 8, Supreme Court Cases, page 129. 2020, Volume 8, SEC, page 129. If you look at the citation of Pune Municipal Corporation, it was 2014. This is 2020. So after 6 years almost. So in this case, what was held? Pune Municipal Corporation was overruled by holding what? By holding that land acquisition proceedings lapse only when the twin conditions are met, not single condition. It's a twin condition. That is, non-payment of compensation to the landowners together with failure of the state to take physical possession of the acquired lands. So, non-payment of compensation to the landowner, that is the first condition. Second condition is failure of the state to take physical possession of the acquired lands. These two conditions are to be fulfilled, only then acquisition proceedings stand lapsed. So, leveraging this, Government of NCT of Delhi, the first appellant herein, approached this court, second round of litigation, dear friends, approached this court through an SLP, wherein BSK Realtors, LLP and DDA were impleaded as the first and second respondents respectively. It was contended on behalf of Government NCT of Delhi that the judgment and order dated 11th of January 2016 rendered by the High Court ought to be considered, ought to be reconsidered in view of Manohar Lal. They are saying Pune Municipal is overruled by a constitution bench. Now again, it has to be decided in light of the newly evolved principle of law in Indoor Development Authority. This was their submission by starting the second round of litigation. But there are preliminary objections. What are those objections? The preliminary objection for the maintainability of the SLP was raised by BSK Realtors. The first contention is in line with doctrine of merger, was that the order of the High Court dated 11th of January 2016 had merged with the order dated 31st August 2016, that is civil appeal of this court, whereby the civil appeal at the instance of DDA was dismissed. Such dismissal, BSK Realtors LLP further contended, was after grant of leave and by a speaking order upon hearing all the parties involved. BSK Realtors also contended that the order dated 11th of January 2016, upon its merger with the Supreme Court order dated 31st August 2016, ceased to exist. Because the High Court order ceased to exist, it loses its identity because it gets merged with the Supreme Court judgment. Ceased to exist, and Government NCT of Delhi, being a party to the civil appeal filed by DDA, the same would disentitle Government NCT of Delhi from initiating a new round of litigation to have the order dated 11th of January 2016 reversed on the specious ground that the decision in Manohar Lal has been rendered after dismissal of a civil appeal of DDA, overruling the decision in Pune Municipal Corporation. Accordingly, it was submitted that the SLP, not being maintainable, deserved outright dismissal. So these were the preliminary objections raised by BSK Realtors. Now let us see the analysis, dear friends. So after hearing both the parties, the issues which are to be adjudicated that they have narrated here under the caption F, analysis. Para 24 of this judgment, having heard the arguments presented by both sides at length on different issues, we propose segmenting our analysis accordingly. The following issues emerge for our consideration. Now, A, whether the dismissal of a civil appeal preferred by one appellant, that is, one appellant means referring to DDA, Delhi Development Authority, whether the dismissal of a civil appeal preferred by one appellant in the first round operates as res judicata against the other appellant. Who is the other appellant? Government entity of Delhi in the second round before us. So, whether res judicata will be applicable in the second round of litigation. Number 2, whether suppression of the first round of litigation by the appellants constitutes a material fact, thereby inviting an outright dismissal of the appeals at the threshold. So, when government entity of Delhi is initiating a second round of litigation, it is a duty bound. It is a duty on part of the entity of Delhi to disclose that already we adjudicated through DDA that was dismissed by a speaking order. That has to be stated. Nothing was stated. Everything was suppressed. Whether such suppression would entitle them from being heard, whether outright dismissal warrants because of suppression of the material fact. C, does the doctrine of merger operates as a bar to entertain the civil appeals in the present case? Because according to BSK Realtors, there is no existence of Delhi High Court order, because High Court order already merged with the Supreme Court judgment. So, therefore, it cannot be challenged again. So, doctrine of merger. Number 4, whether the previous determination of the rights of subsequent purchasers in an interstate dispute precludes the same issue from being reconsidered between the same parties. So, what are the rights of the subsequent purchasers when it was already decided in the previous civil appeal? Whether can it be re-adjudicated in the second round of litigation? These are the 4 issues, dear friends. Now, let us deal with first principle of res judicata. So, what is our understanding about res judicata? See, res judicata is based on the public policy. It is not a technical plea, dear friends. It is based on the strong public policy doctrine. For example, A files a suit before the civil court against B. A is a rich man, B is a very poor man. The issue is whether this X property, whether belongs to A or B. That was the issue. But by considering the material documents, evidences, the Honorable Civil Court dismissed the plaint filed by a rich person A. Now, what is the remedy available to A? Because he has lost it. He has to prefer an appeal. Why he is not allowed to file once again the suit before the same court, adjudicating on the same issue? When we do that, there is no end to the litigation. So, a rich person will keep on filing a case for the same issue before the same court unless and until he gets the favorable order. So, mighty cannot decide over the poor person. So, therefore, there is a scope for appeal, but it cannot be adjudicated before the same court. So, same parties, same cause of action, same issue, and if it is already heard and finally decided, if it is dismissed for non-prosecution, res judicata will not be applicable because civil court did not determine whose right, who has a right over the property. If it is dismissed for prosecution, they can file a suit once again. But if it is decided on merits, heard, and then conclusively determined, judgment was pronounced, then res judicata applies. So, this is the basic principle, that rich should not suppress the poor and there should be an end to the litigation, and no person shall be vexed twice for the same cause of action. So these are all the basic principle involved with respect to the res judicata, and it is my duty to inform that in the year 2017, I also delivered a short lecture on principles of res judicata in the Friday group, dear friends. So YouTube channel, it is available in the Friday group YouTube channel. You can have access to what is the principles of res judicata. It was discussed for a half an hour. You can see that. Now, with respect to this case is concerned, the first issue, we noticed that at the start of our analysis stems from the submissions pertaining to res judicata. The counsel for the landowners, pressing the applicability of the principle of res judicata to the present appeals, submitted that the dismissal of a civil appeal preferred by one of the appellants in the first round would act as res judicata against the other in subsequent rounds of litigation. The appellants contested the same and submitted that res judicata would not apply to the concurrent proceedings. Would the rule of res judicata, now this is a question, would the rule of res judicata operate against, this is very important, please, would the rule of res judicata operate against the co-respondents? In the first round of litigation, DDA preferred. Thereafter, Government NCT of Delhi preferred. But both arrayed as co-respondents in the first round of litigation before the Delhi High Court, BSK Realtors versus Government NCT of Delhi, respond number 1. Respond number 2 is DDA. So, whether res judicata will be applicable with respect to the first civil appeal preferred by DDA and second petition preferred, second SLP preferred by Government NCT of Delhi. This is what the issue, that this is where it becomes a leading case, dear friends. Would the rule of res judicata operate against the co-respondents before the High Court, namely Government NCT of Delhi and Delhi Development Authority, and preclude us from looking into the merits of the present set of appeals, is the question that we propose to examine and answer now. So now the Honorable Supreme Court is going to deal with whether co-respondents case filed, whether res judicata will be applicable or not. Nearly a century ago, now Honorable Supreme Court relying upon the precedents. Nearly a century ago, a bench of 3 honorable judges of the Privy Council, so Lordships, they are relying upon the Privy Council judgment in Munni Bibi versus Triloki North. This was cited in 1931, SCC Online, Privy Council, page number 20. Lay down the following 3 conditions for the application of res judicata between co-defendants. So, when it is co-defendants, there are 3 principles to be, conditions to be fulfilled. See, a century back still holds the field. This is a beauty of the precedent. That number 1 condition is, there must be a conflict of interest. There must be a conflict of interest between the defendants concerned. Number 1. Number 2, it must be necessary to decide this conflict in order to give the plaintiff the relief he claims. Number 3, the question between the defendants must have been finally decided. So these are the 3 conditions that is to be fulfilled. But here let us ask a question, dear friends. Was there any dispute or conflicting interest involved between Delhi Development Authority and Government NCT of Delhi? The answer is no. There was no conflict of interest. Both sail in the same boat. DDA has failed. Now the Government NCT of Delhi is coming. But beneficiary is DDA only. So no conflicting interest. Let us see. So they are relying upon one more judgment. In State of Gujarat versus MP Shaw Charitable Trust, a bench comprising of 2 honorable judges ruled that principle of res judicata applies only when there has been a directly and substantially disputed issue between the parties, which the court has heard and conclusively resolved. So there must be a substantial issue involved between 2 of the parties. and that issue must have been resolved by the court. But in this case, no conflicting interest. In the lead matter before us, but so by relying upon the law of precedent, now the Honorable Supreme Court comes to the conclusion in para 29. In the lead matter before us, or for that matter the other appeals, the co-respondents before the High Court, namely Government Entity of Delhi and Delhi Development Authority, did not have conflicting interest. They do not have any conflicting interest between them. Number one. Inter se them, neither was there any disputed issue. There was no disputed issue between the parties, nor could have the High Court possibly adjudicated on any such issue. Before this court too, in the first round, there was no issue on which Government Entity of Delhi and DDA were at loggerheads. What is the meaning of loggerheads? Two or more parties are in strong disagreement. So here no disagreement between Government Entity of Delhi and DDA. In light of this, in accordance with the aforementioned legal principle, the applicability of res judicata is negated, is rejected. So meaning thereby res judicata will not be applicable here. Will not be applicable because there was no conflicting interest. When there was no conflicting interest, there was no occasion for the High Court to decide the list between the parties. Therefore, res judicata will not be applicable. This is the first finding, dear friends. And many other law is also discussed here. Finally, at para 32, the law, as we noticed aforesaid, aptly resolves the first issue. Res judicata as a technical legal principle operates to prevent the same parties from re-litigating the same issues that have already been conclusively determined by a court. However, it is crucial to note that previous decision of this court in the first round would not operate as a res judicata to bar a decision on the lead matter and the other appeals. More so because this rule may not apply hard and fast in situations where larger public interest is at stake. When the question of public interest is involved, we cannot apply this principle of res judicata in a very strict manner. So in such cases, a more flexible approach ought to be adopted by courts, recognizing that certain matters transcend individual disputes and have far-reaching public interest implications. So res judicata is not applicable because no dispute between the parties, that is DDA and Government Entity of Delhi. There is a change in the position of law. When there is a change in the position of law from Pune Municipal Corporation to Manohar Lal, res judicata will not be applicable. Number two, this is second condition. Number three is when there is an involvement of public interest, because the land speaks for acquired for the public interest. So in such a scenario, res judicata is not applicable. So these are the three conditions, dear friends. No conflicting interest. Number two, change in law from Pune Municipal Corporation to Indore Development Authority Manohar Lal. Number three is when there is element of public interest involved, res judicata will not be applicable in a strict manner. So this is their answer to the res judicata is concerned. Now coming to the second point, suppression of material facts by appellant. A bench of two judges of this court, now again lordships relying upon the precedent judgments. A bench of two judges of this court in SJS Business Enterprises Private Limited versus State of Bihar held that a fact suppressed must be material. So when we say it is a suppression of material fact, that fact must be material. That is, if it had not been suppressed, it would have influenced the merits of the case. It was held thus, as a general rule, suppression of a material fact by a litigant disqualifies such litigant from obtaining any relief. Reason is, a person who knocks the doors of the court, he must approach the court with clean hands. If he wants to misrepresent the court, if you want to mislead the court or suppress the material fact, then he is not entitled to be heard. He is not entitled to get any relief, be it interim or final, because this amounts to playing fraud upon the court. When you are coming to the court, you should give a complete, true disclosure of the facts. So here, as a general rule, suppression of a material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the court to deter a litigant from abusing the process of court by deceiving it. No litigant should be allowed to deceive the court. But the suppressed fact must be a material one in the sense that it had not been suppressed, it would have had an effect on the merits of the case. It must be a matter which was material for the consideration of the court, whatever view the court may have taken. Assuming that the explanation given by the appellant that the suit, this they are relying upon some other judgment, dear friends, let me come to the conclusion. Law is well settled by relying upon several judgments. The Honorable Supreme Court at the concluding part, para 37. Law is well settled that the fact suppressed must be material in the sense that it would have an effect on the merits of the case. The concept of suppression or non-disclosure of facts transcends mere concealment. It necessitates the deliberate withholding of material facts, those of such critical import that their absence would render any decision unjust. Material facts in this context refer to those facts that possess the potential to significantly influence the decision-making process or alter its trajectory. Alter its trajectory means changing the course of action. This principle is not intended to arm one party with a weapon of technicality over its adversary, but rather serves as a crucial safeguard against the abuse of judicial process. Nevertheless, now how they are applying to the present case? By seeing the precedents, now they are applying to the present case. In this case, NCT of Delhi suppressed the first round of litigation. How? What is the finding at para 38? Nevertheless, we have carefully considered the orders issued during the first round of litigation, which are alleged to have been suppressed. Despite reviewing these orders, we find no compelling reason to dismiss the appeal based solely on the prior dismissal of appeals filed by some other appellant or authority. So in the first round, DDA has filed it. In the second round, government NCT of Delhi has filed it. But we don't find that by suppressing the first round of litigation that they are not getting any benefit out of it. So it is not a material suppression. Ultimately, what has gone through the minds of the honorable judges was public interest. This is only mere technicality. So public interest is there. So therefore, we need to decide this case. Therefore, they have said material suppression of the first round of litigation will not outrightly, we will not dismiss it. The civil appeals, we will hear it because it involves public interest. Now, doctrine of merger. Whether in the first round of litigation, whether Delhi High Court order got merged with the Supreme Court judgment dated 31st of August. Now, what the Honorable Supreme Court has discussed. In light of the settled propositions on the doctrine of merger and the rule of stare decisis, we respectfully concur with Kunaya Ahmed case. This is very leading judgment, dear friends, regarding doctrine of merger is concerned. That is 2000 volume 6 SCC 359. Kunaya Ahmed versus State of Kerala, 2000 volume 6 SCC, page number 359. We respectfully concur with Kunaya Ahmed and the decisions that have followed the same. We also take notice of the exception carved out by this court in Kunaya Ahmed to the effect that the doctrine of merger is not of universal or unlimited application, and that the nature of jurisdiction exercised by the superior forum and the content or the subject matter of challenge laid or which could have been laid shall have to be kept in view. The exception in our considered opinion, now they are drawing the exception to the doctrine of merger. The exception in our considered opinion that has been carved out in Kunaya Ahmed will only be permissible in the rarest of rare cases, and such a deviation can be invoked sparingly only. We, however, this is most important, dear friends, how the doctrine of merger is not applicable in the present case, the Honorable Supreme Court is explaining now. However, we, however, hasten to add that among such exceptions, the extraordinary constitutional powers vested in this Supreme Court under Article 142 of the Constitution of India, which is to be exercised with a view to do complete justice between the parties, remains unaffected, and being an unfettered power, it has limitless power. Sky is the limit. Shall always be deemed to be preserved as an exception to the doctrine of merger and rule of stare decisis. So, doctrine of merger, doctrine of stare decisis will never come when the Honorable Supreme Court is exercising its inherent power, that is Article 142, to do complete justice. Here, to do complete justice for the public interest. So, we may now at this stage look back to the preface of this order, where we have encapsulated our predicament to not only uphold the law, but also to ensure its consistent application. It is our duty to enable consistency, clarity and coherence, and strike a delicate balance through harmonious resolutions regardless of the crisis, chaos and confusion created by inconsistent judicial opinions on section 24 subsection 2 of the 2013 Act, making the present batch of lists a sui generis dispute. Now, this is what with respect to the doctrine of merger, dear friends. Now, ultimately, several other issues are also discussed, but let me read the relevant portion. Finally, we issue the following directions. 63.1. The Chief Justice of the High Court is requested to constitute a dedicated bench to decide these repetitions. Chief Justice of Delhi High Court, in the manner indicated hereafter, the nominated bench will accord an opportunity to the landowners, subsequent purchasers, the government NCT of Delhi and Delhi Development Authority to submit additional documents and affidavits, whereupon such bench shall embark on an exercise to decide who between the landowners and the subsequent purchasers is the right claimant to receive compensation. Landowner sold the property to the subsequent purchaser, but now the dispute between landowner and the subsequent purchaser is we will receive the compensation. So, who has to receive the compensation? That has to be determined by the Delhi High Court. The nominated bench will have the authority to obtain independent fact-finding inquiry reports if deemed necessary. The inquiry could include determination as to whether, after notification, section 4, subsection 1 of the 1894 Act, any transfer could have been effected or even if effected, whether such transfer is permitted by law. So, accordingly, dear friends, they have given certain directions to the Honorable High Court, but I wanted to bring it to your notice while invoking Article 142. This would be my final submission on this. Regarding 142, how they have dealt, the Honorable Supreme Court, since the landowners are not primarily dependent upon the subject land as their source of sustenance, and most of these lands under the use for other than agriculture purpose, we deem it appropriate to invoke our powers under Article 142 of the Constitution and dispense, this is why I am reading, for this purpose I am reading, dispense with the complaints of Chapter 2 and Chapter 3 of the 2013 Act, whereunder it is essential to prepare a social impact assessment study report and to develop alternative multi-crop irrigated agricultural land. We do so. Why do we do so? By waiving this compliance, we do so to ensure that the timeline of 1 year extended at para 58.1 above to complete the acquisition process can be adhered to by the appellants and the government of NCT of Delhi, which would also likely to be beneficial to the expropriated landowners, and several other sections were also waived. So statutory mandate of compliance was waived by the Honorable Supreme Court by invoking Article 142, dear friends. Therefore, statutory provisions can be waived under 142. It's a completely no boundaries for Article 142 to do complete justice. What is complete justice? Depends upon the facts and each facts of each case, what the Honorable Supreme Court wants to do. So therefore, the Supreme Court remains a supreme because of many reasons, more particularly of Article 142. So why this case is a leading case? Because res judicata is involved, principle of res judicata with respect to co-defendants, co-respondents. Thereafter, merger is involved, doctrine of merger. Generally, the settled proposition is when there is a material suppression of the fact, based on that, it can be outrightly dismissed. But here it is an exception. Why? Because of change in law also, because of the public interest also. And then they have again remanded the matter to the Delhi High Court. Some of them are dismissed. There are different categories of cases, dear friends. So therefore, we focused only on the principle of law and what is to be written for AOR examination. Thank you so much for your patience hearing. Thank you so much.